So thank you so much for having me here today to present my work that is joint work with my co-author Colleen Cunningham, who is an assistant professor of strategy and entrepreneurship at London Business School. So the paper I'm presenting today is entitled Keeping Invention Confidential, the Role of Strengthened Legal Protections in the Use of Trade Secrets. So the photo here in the background is that of an oil well site because the context of the paper is the hydraulic fracturing sector in the US. So innovation, which can be understood as the invention and commercialization of new things, is, as we know, an important driver of firm performance and economic growth. Now, one of the main ways that firms are incentivized to invent is via IP protection policies. Now, we know a lot about innovation as it relates to patenting, but a number of different studies has shown that trade secrets are more commonly used, more so than patents, by firms across locations, industries, time, and also that often firms prefer to preserve their larger, more important inventions via trade secrets. So we know considerably less about secrecy as a way to protect intellectual assets, which of course is understandable because it's difficult to observe. Now, innovation scholars have examined the effect of trade secret protection on patents and R&D expenditure, but we do have scant evidence on trade secrets themselves. So the question that we ask in this paper is, do firms increase secret invention when this secret invention is more protected? So in particular, we look at how stronger trade secret protection affects the use of trade secrets, the use of new secrets, and the overall recombinatorial nature of innovation at the project level. So we study whether firms source secrets from third parties or generate them inside the firm, whether the breadth of innovation increases, and whether the complexity of the project changes when trade secrets are more protected. So as you can see, we investigate whether firms are actually creating new inventions. And I will talk about this more, but secrets can be used indefinitely. And so we really want to get at whether stronger trade secret protection incentivizes innovation. So to this end, we investigate in these various ways whether there's evidence of innovative activity. The context of the study is the hydraulic fracturing industry in the US between 2013 and mid-2018. And in terms of identifying the effects of stronger legal protection, we exploit the change in the regulatory regime. So we look at how the passage of the Defend Trade Secrets Act in 2016 affected states with varying levels of pre-existing trade secret protections. So what are trade secrets? Well, trade secrets are defined as some sort of information, including a formula, pattern, compilation, program, device, method, technique, or process that needs to qualify in order to be protected as a trade secret along two dimensions. So first, the firm has to derive economic value from it, whether actual or potential, because of that invention not being known to others. Second, the firm has to take reasonable efforts to protect the secrecy of that intellectual asset. Now, what are some of the examples of trade secrets? So one type of trade secrets are algorithms, like Google's algorithm that determines how search results are filtered, or the New York Times bestseller list. Another type of a trade secret is a process, like the production of different chemicals. And here, often innovation scholars have assumed that if a firm has more process patents, it also has more trade secrets. Another type of trade secret is a recipe or a formula, like the alloy or the mixture of metals that is used to produce this, these Zildjian cymbals, which is a percussion instrument that was first invented in 1618, and that is still protected via trade secrets. Another example is Marmite, which is quite popular here in the UK, and apparently some people eat Marmite. Another one is Angostura bitters used for cocktails like pisco sour, and I have an amazing anecdote about the label of Angostura bitters if you're interested later on. So what we're going to do is we're also going to look at a recipe of sorts, which is the set of ingredients that go into a well during a hydraulic fracturing operation. So we saw how we define trade secrets. We saw some examples of them. And I just want to briefly highlight a few things to delineate some differences of trade secrets from other intellectual property assets. So the benefit of using trade secrets is that there is no need to wait for approval from authorities, and there is an unlimited time of protection. So another famous example of a trade secret is the recipe of Coca-Cola, and the company has been able to preserve the recipe from falling into the public domain since late 19th century because it did not patented it. So some drawbacks of trade secrets are that a firm needs to be continually exercising efforts to protect the secret from leaking. And the secret can anyway be independently discovered, in which case no one gets any protection. The secret can also be reverse engineered, which is why certain inventions are more likely to be patented than protected by trade secrets when reverse engineering is relatively easy. So the tension that arises with trade secrets is that it may be economically useful to use them, but it potentially exposes the firm to disclosure. So we would anticipate that firms will take into account the regulatory environment when they consider whether to use a trade secret and whether to use new trade secrets. So now that we have an idea of what trade secrets are, what are the predictions that we make in this paper? So we anticipate that trade secret use should be affected through two channels. First, directly through the increased appropriability. So firms will now know that it is much more costly to steal their secrets, so they will use their existing inventions more. Second, because of this increase in appropriability, which the literature has shown for other types of legal protections like patents and copyrights, there should be an increase also in new invention when there's more protection. So we also anticipate that there's this generation of new secret invention that increases when there's stronger protection. However, we also consider a secondary indirect channel, which is specific to trade secrets, which is this idea of a decrease in spillovers. So a big innovation literature documents how firms build on the knowledge of others. And so we would expect that this lack of learning may also affect secret invention. However, the lack of learning should not affect existing secret inventions because firms will just use the existing ones more. But over the long term, we may see some impact on new invention. So what we propose is that the effect of trade secret protection will affect the use of trade secrets and the generation of new secrets. And in this particular study, we look at a relatively short period of 2 years in the post period after the enactment of these stronger laws. So we expect that both the use and the generation of secrets would increase. Now, another set of questions that we investigate is, does the trade secret protection change in some way the nature of innovation? Now, what do we mean by nature of innovation? We investigate this idea of recombinatorial nature of innovation. So we study several dimensions that have been deemed important in the innovation literature. One is the sourcing of inventions. So we're studying whether firms produce the inventions themselves or whether they source them externally from third-party producers. With the strengthened legal protections, we would expect that markets for technology become more active, but also that firms themselves may have higher incentives to generate secrets internally. So what we will do is we will look at whether firms seem to be using the internal and external inventions separately, or whether they are combining them within the same projects, which in our case are wells. Also, we're looking at whether the secrets cover a broader set of so-called classes, or what we call purpose groups in this setting. And this helps us get at the breadth of secret invention. And finally, we study whether firms carry out seemingly more complex projects, looking at the number of ingredients or components that they use in each project that they undertake. So taken together, these measures are trying to get at the recombinatorial nature of projects, again, trying to understand whether stronger trade secret protection is associated with more innovation. So once again, the context of the paper is the US hydraulic fracturing industry, where we observe the use of trade secrets because firms have to file forms for each trade secret that they want to use in a well. So while in most contexts, firms can just use trade secrets without any database that would ascertain their incidence, here we have a regulated industry that is required to disclose ingredients, all ingredients, except if these ingredients are trade secrets. So the share of production from wells drilled using hydraulic fracturing went from around 5% in the early 2000s in the US to around 75%. So this is a very important increase. And what this also means is that there has been a lot of experimentation and invention in this space over this period. So what is hydraulic fracturing? So let me just give you a very quick primer. It is a process that is characterized by two aspects. One is a large volume of fluids, so hence the hydraulic part. And the second is the stimulation of the rock, so the fracturing part, hence hydraulic fracturing. So traditional wells usually drill down vertically. They hit what is called the target zone, and they will extract the hydrocarbons from that underground reserve. Now, wells that are hydraulically fractured will start off using the same drilling process, but once the target zone is reached, the drilling bit, the machine that drills, turns 90 degrees to drill the horizontal part of the well. So then the well is perforated with a gun and hydraulic fracturing begins, which takes several days of fluids being pumped down the well into the rock formation under high pressure. The fracturing fluid is generally comprised of around 90% water, 9.5% of sand or proppant, which props the fractures open, and 0.5% of chemicals. And the volume of this fluid is huge and can use anywhere between 2 to 5 Olympic swimming pools of fluid. So this fluid expands within the perforations, causing the fractures to open up. And the ingredient that keeps the fractures open is called proppant. And it's a particularly important ingredient on which the success of this operation largely depends. So hydraulic fracturing can expand from a few thousand to over 10,000 feet horizontally, so going several kilometers, in order to capture all the oil and gas that is captured in that zone. So as I said before, we will be looking at the composition of this fracking fluid mix, and we will study it at the well level. Now, how do we build the sample for the study? So since at least 2013, disclosing fracking fluid ingredients is mandated in most states in the US. Then in a subsample of these states, claiming a trade secret implies some sort of costly action, like filing a form to the authorities, explaining the measures taken to protect the secret, why it is important, disclosing the chemical family, and sometimes the volume that the ingredient uses. So here's an example. In Wyoming, for instance, firms are required to report that for a requested trade secret, chemical ingredients are not already public, that steps have been taken to safeguard it, that it is not deemed as not protected, that it is commercially valuable to the firm, and that in the case of disclosure, the firm would suffer because of reverse engineering. So our sample consists of states where disclosure is mandated and where firms have some trade secret submission rules, which leaves us with 7 states, around 47,000 wells, 52 supplier firms, which are the firms that carry out the hydraulic fracturing operations for their 460 clients, which are the oil producers or operators. So the service companies are firms like Schlumberger, Halliburton, Calfrac, and producers are firms like Chevron, Exxon, EOG Resources, and so on. So what does an example of a well ingredient list looks like, and how do we operationalize our measures? So here's a list of ingredients with their names, chemical abstract service number, and the chemical purpose groups. And this categorization gets at the purpose that a particular ingredient fulfills. There are 19 of these purpose categories. They generally are meant to increase the output of the well by affecting the fracture size, reducing appearance of bacteria, facilitating the mixing of the different ingredients, and so on. So first, we record whether the ingredient is classified as proprietary or trade secret based on the information of the identity of the ingredient. Then we investigate whether the well has any trade secrets and how many of them it has. We also identify whether the ingredient is propant, which, as we argued, is a critical ingredient in the fracturing process. And we do this because we're trying to get at the idea of whether firms are only using trade secrets in some fringe categories or whether they're actually using trade secrets in important critical categories. Then, using the information on the chemical purpose group, we investigate whether the focal firm, so the service firm, is entering a particular chemical purpose group with that well for the first time. And this is how we determine whether the secret is new to the firm and how many of such new secrets the firm is using. Finally, we examine the origin of the secret, so where it is sourced from, whether it's a third party or within the firm, the breadth of the secrecy that we measure with the number of categories of secrets, and the complexity that we measure counting the number of ingredients. So for instance, for this particular well, we would see that there are trade secrets in it. There are 2 trade secrets. They are not important according to our definition. They do not span propant as a chemical purpose group. From this, we cannot tell whether they're new secrets because we would have to look at the history of the firm. And also as a separate variable, we look at who provides the trade secret. The breadth would be 2 categories because the secrets span 2 different categories and the well has 17 ingredients. So we chose a well that has relatively few ingredients here. We use the Defend Trade Secrets Act, which came into force in May 2016, which was considered by legal scholars as the most significant expansion of IP law in at least 30 years. It added a federal jurisdiction to the cases of trade secrets and significantly increased the damages associated with that, including the seizure of assets, tripling the damage repayments, and instituting royalty payments to the victims. So we exploit the variation among the different states in terms of their pre-DTSA levels of trade secret protection. This is an approach that is similar, for instance, to Amy Finkelstein's paper on Medicare, which was rolled out federally at the federal level, where she exploited the pre-existing levels of private insurance. So we use the index provided by Ivan Ping on the state level variation in trade secret protection before DTSA. And we group states into high treatment states and low treatment states. So high treatment states have a low pre-DTSA level of trade secret protection, and low treatment states have a high pre-DTSA level of trade secret protection. So let's dive into the data. So again, we have around 47,000 wells. We have a lot of different DVs here, so I grouped them and we can quickly go over them. So we see that around 56% of the wells have a trade secret in them. On average, a well has around 2 secrets. 20% of the wells have an important secret. Now looking at the new invention, we see that around 2% of the wells are wells with which a firm enters a new category for the first time. We also count the number of those secrets. And then looking at the recombination, we see that in terms of sourcing, firms have around 34% of the wells have some internally generated trade secret. Around 33% have some externally sourced trade secret. Among the wells that have trade secrets, 20% have only internally generated secrets. Around 40% have only externally generated secrets, and 40% have both. In terms of the breadth, we see that an average well has 1 trade secret category and 11 non-trade secret categories. And in terms of the number of ingredients, there's around 39 ingredients and around 5% are trade secrets. So I'm going to present to you several graphs that pretty much tell the story of the paper, and then we'll go into regression analysis. So first, we see that when we compare the period before DTSA and after DTSA, there's a marked increase in terms of trade secret use. So if on average before DTSA, there was around 45% of wells that use trade secrets, in the period after, there's around 77%. Now, if we split this by the type of states, we see that this increase is very much driven by high treatment states. So here, the incidence of trade secrets goes from around 25% to 73%, while for low treatment states, it goes from 47% to 77%. Now we see something similar if we look at the number of trade secrets per well. So we see that on average, there was around 1.4 secrets in the period before and around 2.4 secrets in the period after. If we split it by the type of the state, again, we see that in high treatment states, there was around half a secret per well on average. And in the after period, there was around 3.1 secrets. While for low treatment states, there was around 1.6 secrets per well, so a higher level to begin with, that went up to around 2.4 secrets per well. So now let's look at regression analysis. All of these regressions are OLS. We include a bunch of fixed effects where we're trying to control for the stable characteristics of the firm. So the supplier firm, the focal firm, the operator or the oil producer, the well type. So whether it's oil or gas or oil and gas, the basin. So we try to get at the geography and we include a time trend. So we see that in the after period post DTSA, there's an increase in trade secret use. So the probability that a well would include a trade secret goes up by around 11 percentage points. And this effect is, there's an added effect of 22 percentage points for high treatment states. We see something very similar for the number of secrets. So again, in the period post DTSA, there is an increase, and in particular, so for high treatment states. In terms of important secrets, we see also that there's an increase in the use of these secrets. So again, these are secrets that are in this propant category. And there's an added effect for high treatment states. Now, if we investigate the use of new secret inventions, we see that there is, again, an increase in the post period. Remember that the average was around 2%. So an increase by 3 percentage points is really large. And there's an added effect for high treatment states. Similarly, for the number of secret ingredients in these new categories, there's an increase. So what we see is that there's both an increase in the use of trade secrets and in the use of new trade secrets. Now, turning to this investigation of the nature of innovation, first we look at who provided the trade secrets. So we look at whether it's internally generated or whether it's externally sourced. What we find is that there's an increase in both. So firms seem to both increase their internal trade secret generation and also use more externally sourced trade secrets. Now, what could be happening is that firms are bifurcating their these inventions, and they're using some trade secrets only. So they're using trade secrets that are externally sourced in some set of wells and internally generated trade secrets in another set of wells, or they could be mixing them and combining them. And we find evidence that perhaps the latter is happening. So we see that the use of both internal and external secrets in these high treatment states after DTSA increases. Now, looking at the breadth of innovation. So again, here we're looking at the categories that the trade secrets span. So remember the categories where things like propant, buffer, clay control, and so on. We're looking at how many of these different categories the trade secrets span. If you remember, the average was 1.06. So here we see that in the aftermath of DTSA, there's an increase by around 0.4, 0.3, and there's this added effect in high treatment states. So here there's almost a doubling of the number of the breadth of innovation. We also look at whether the number of categories that non-trade secrets span increases, and we don't find evidence for that. So it seems that any increase in the different categories that wells have, that wells span, is driven by trade secrets. Now, we also investigate this idea of complexity of projects, looking at the number of components or number of ingredients. We see here also that after DTSA, there seems to be an increase in the number of ingredients, that on average, high treatment states had lower level of ingredients, but that this kind of results in this added effect in the post period. So we see that they're kind of catching up with the other states. We also check the proportion of trade secrets within wells. We see that there is an increase in this dimension as well. So it seems that in the aftermath of DTSA, there's a higher complexity of wells in terms of the number of components that they use. Now, finally, we will look at the heterogeneity that may be driving these results. So what we do is we split the sample by large firms and small firms, where large firms are those that have above the median level of wells in a given year that they hydraulically frack, fracture, and the inverse for small firms. And we see that it looks like it's the large firms that are driving the use of trade secrets, while it is the smaller firms that are driving the use of new trade secrets. So in the paper, we have additional analyses that look at things like competition. So we look at how many other competitors there are in a county and how that affects trade secret behavior by firms. We look at inter-firm exchange relationships, so the history of relationships between the supplier firms and the operators, the oil producers, and how that affects their use of trade secrets. We also use alternative measures for some of these constructs. I just want to say one word about something that you may be thinking about. So one concern you may have is that these measures of trade secrets are simply an indication of firms concealing bad behavior or using toxic ingredients. So what we did is we matched the disclosed ingredients in these wells with information from toxic release inventory data. And we found that virtually all wells, so 97% to be precise, have toxic ingredients. And they have on average around 6 toxic ingredients, regardless of whether the well has trade secrets or not. So what this suggests is that it is not the case that trade secrets are merely a way to hide toxicity, because the toxicity is already widely used and disclosed. So in summary, we find that strengthening of trade secret protection increases the use of trade secrets and the generation of new trade secrets. There's also a reconfiguration of innovation in terms of sourcing of inventions, their breadth, and the complexity of projects. We also find that larger firms are more likely to use and smaller firms are more likely to generate new trade secrets following the enactment of DTSA. And the contributions that we're trying to make are, of course, to the innovation literature. So first, we offer a more complex picture of stronger trade secret protection on innovation than perhaps suggested by current literature, when innovation is mainly measured by patents. So in fact, we show that trade secret use and new invention increase following the enactment of stronger trade secret laws. So even though patenting decreases, it is not clear whether the overall impact on innovation is negative. Also, we add within firm and over time evidence of the drivers of secrecy use, complementing the existing survey-based studies. And finally, we aim to add to the markets for technology and open innovation literatures, showing that stronger trade secret laws also facilitate the sourcing of trade secrets and these types of inventions in markets for technology, but that they also incentivize internal secret generation. So with that, thank you very much. I'm keen to hear your comments, and thanks again for the discussion, Ashish.